Okay, well, good afternoon. Welcome to the second seminar of the 6th season of the Legal Philosophy Between State and Transnationalism series of the Nathanson Centre on Transnational Human Rights, Crime and Security, which for the first time this year we're combining with a seminar that is cross-listed both here at Osgoode Hall Law School in the Philosophy Department. And we're very excited to have with us for the second seminar Dr. David Rodin. Dr. Rodin is a senior research fellow at the University of Oxford in England, where he co-directs the Oxford Institute for Ethics, Law and Armed Conflict, otherwise known as ELAC. He's also a senior fellow of the Carnegie Council for Ethics and International Affairs in New York. His publications include a number of books, notably the bestsellers Preemption with Oxford University Press in 2007, Just and Unjust Warriors at Oxford University Press in 2008, and the book that started it all, War and Self-Defense, again at Oxford University Press in 2002, which indeed was awarded the American Philosophical Association Sharp Prize, as well as he's also published articles in leading philosophy and law journals. So we have together with us today one of the leading theorists of war, just war theory, and so we're very, very happy about this. Dr. Rodin is also a Rhodes Scholar from New Zealand. He has a BPhil and a DPhil in philosophy, again from the University of Oxford. He obviously has a busy teaching and consulting schedule, and he's a regular lecturer at the UK Joint Services Command and Staff College, where he actually provides ethics training for senior officers up to the rank of two-star general, no less. He's also worked in the private sector, quite peculiar for a philosopher, as a senior associate at Boston Consulting Group, so it gives him a unique perspective on problems of philosophy. And in 2011, he was honored by the World Economic Forum as a young global leader, which is a program which is recognizing the most distinguished young leaders in all fields below the age of 40. We're very fortunate to have him with us today, and he's going to present a paper entitled The Reciprocity Theory of Rights. So without further ado, Dr. Rodin.
Great. Well, thank you very much, Francois. It's really wonderful to be here. My very first time in Toronto, and the weather is great. So great to be here. As Francois said, I do a lot of work on the ethics of war and the ethics of killing. But in this paper, what I attempt to do is to stand back and to reflect a little bit more generally on rights themselves, on what they are, where they come from, and why they behave in the ways that they do. And so it's an attempt really to try and say something new about a set of quite old questions that have worried theorists of rights for a long time. So we know that we have rights of many different kinds. We have rights against being harmed in certain ways, and we have also rights to be assisted or aided in certain ways. Now, those are all rights, but they present to us in very different ways in a lot of different contexts. So a couple of the ways in which intuitively they seem to differ very significantly is in the kind of stringency that they reflect. So to give one example, think about the costs that one can be required to bear in order to fulfill the requirements of a right. The costs that you can be required to fulfill to respect another person's rights against being harmed are very, very high. In certain circumstances, you might be required even to suffer death so as not to violate the significant rights against harm of others. Rights to assistance don't seem quite like that. You can be required to bear certain costs to assist other people in times of need, but it's very unlikely that you could be required to bear such a high degree of cost that it would cost you your life, even if the life of the person who required assistance were at stake. That's one difference between them. There are also differences in terms of the enforceability of those rights. Right? So rights can be enforced in various different ways. They can be enforced through taking defensive action, right? So rights of self-defense to stop a person from violating someone else's right. They can be enforced through the imposition of requirements to pay compensation, and they can be enforced punitively. But when we look at rights against harm compared with rights to assistance, we find that the things that you can do to enforce rights against harm are again much higher than they are in terms of rights to assistance. So for example, if you were to try and violate my right to life, I could kill you in self-defense. Right? So I can enforce my right against harm by using private lethal force against you. I can't do that to force you to respect your right to assist me, again, even if my right to life were dependent on that. And that's another intuitive difference. So I want to say something about this intuitive difference and try to provide a kind of theoretical basis for why those different rights may present in those different ways. And I also want to say something about another very important feature of rights, which is the fact that they can alter their configuration over time. And in particular, that they can do this through mechanisms of forfeiture. Right? So we often say that certain kinds of rights, human rights, are inalienable and possessed merely because of the fact that the recipient is a human being. Now that turns out to be wrong. No rights, or at least core human rights, many core human rights, including the right to life, can in fact be alienated. They can be forfeit on the basis of engaging in wrongful action against others. We see that very clearly in the case of self-defense. So rights have this kind of what I call a dynamic element. They can change their configuration. Rights can be lost and forfeited and alienated in particular kinds of contexts. And it's very crucial that our theory of right be able to explain that. Now I'm going to suggest that some of the classical theories of rights, and in particular the interest theory of rights that I'm going to talk quite a bit about in this paper, have a great deal of difficulty accounting for these different elements of rights. The different stringency that these rights intuitively seem to possess, and these mechanisms of forfeiture. And what I'm going to try and do is persuade you that new theory of rights that I call the reciprocity theory can do a better job at explaining these intuitive differences. So I'm going to go ahead and read parts of this paper. I know some of you have read it already, but I'm going to read kind of the core elements of the argument, and then hopefully we can use that as the basis for a fuller discussion as we go along. So, the reciprocity theory of rights, an important class of interpersonal rights, I want to claim, are best understood as deriving from reciprocity relations between moral agents. The difference between rights to assistance on the one hand and rights against harm stem from the different ways that these two forms of rights and their correlative duties arise out of moral reciprocity. Rights against harm are in part grounded in reciprocal compliance with moral obligations. Rights to assistance are grounded in part in reciprocal expectations of future compliance with moral obligations, in a way that I'm going to explain as we go ahead. And this difference, I think, explains some of these intuitive differences in the way that rights present. So the reciprocity theory begins from a basic hypothesis about the genesis of rights. And the hypothesis is this, that agents can come to possess rights when they comply with the obligations generated by the rights and status of others. That's the basic idea that I want to develop here to get this theory going. Rights, in other words, may arise out of moral reciprocity. The mechanism by which rights are generated through reciprocity is one of the most basic and deeply rooted in moral psychology, the requirement to give respect and consideration to those who give respect and consideration to us. So let's begin with rights against harm. Consider a paradigmatic right against harm, such as the right not to be killed. This right, I claim, is best explained by mutually supporting reciprocity relations between the two moral agents in question. I have the right that you not kill me because, and to the extent, that I comply with your right that I not kill you. Similarly, you have the right that I not kill you because, and to the extent, that you comply with my right that I not kill you. As is suggested by these two clauses, the because clause and the to the extent clause, the reciprocity theory has two components. First, reciprocity functions as the justificatory ground of the right. It explains why we have the right, and crucially, as I'll explain below, why it has the stringency that it does. Second, reciprocity provides an account of the conditions for possession and loss of the right. Right, so it tells you when you have the right and when you've alienated it, when you've forfeited it. Both components are necessary features of a satisfactory normative theory of rights. However, the latter has in general been poorly served by existing accounts of rights. A significant benefit of the reciprocity theory is that it provides a better account than rivals of the conditions for possession and loss of rights and duties. So let's start here. So as I suggested in my introductory remarks, one of the most important features of rights is that they are dynamic in nature. By this I mean that rights are capable of altering their configuration over time in determinate ways. They can be lost or forfeit as a consequence of responsibly infringing the rights of others, right? So you infringe the rights of others, you can lose rights by becoming liable to punitive action or defensive action or requirements to pay compensation. So a critical test for any theory of rights is that it can coherently account for both the conditions for the possession of the rights, right, conditions for why you have the rights, and the conditions for forfeiture, right, conditions for how you can lose the rights. This is a task that the interest theory of rights in particular has a great deal of difficulty in performing. And I'm here going to focus on one of the most influential modern accounts of the interest theory, that given by my colleague at Oxford, Joseph Raz. So this is his kind of canonical statement of the interest theory of rights. So Raz says, X has a right if and only if X can have rights, it's a kind of agent that can possess rights, and, other things being equal, an aspect of X's well-being, in other words his interest, is a sufficient reason for holding some other person to be under a duty, right? So you have a right if you have interests that are sufficiently weighty that that's a basis for holding another person to be under duty. That's just what a right is for Raz. As I say, that's one of the canonical statements of the interest theory of rights. Now, the reason that the interest theory has difficulty with forfeiture is that it fails to account for the fact that the conditions for the possession of a right, why you have the right, and conditions for the forfeiture of a right necessarily have to be correlative. I'll call this requirement the forfeiture principle, and we can formally specify it as follows. So the forfeiture principle says, if X is a necessary condition for the possession of Y, then the absence of X is a sufficient condition for the forfeiture of Y, right? That makes sense. If X is a necessary condition for possessing Y, then obviously the absence of X must be a sufficient condition for the forfeiture of Y. And conversely, if X is a sufficient condition for the forfeiture of Y, then the absence of X is a necessary condition for the possession of Y. So I take that to be just a purely general logical requirement for the relationship between the possession conditions and forfeiture conditions of anything, right? Not just rights, not just moral rights, but anything. If we're going to talk about conditions for having something and conditions for losing something, they have to be correlative in this way, right? Now, utilizing this principle, we can pretty easily show that, contrary to what Raz says, possessing an interest in X is neither a necessary nor a sufficient condition for possessing a right to X. So let's take each of these claims in turn. First, the necessary condition claim. So if we accept, along with standard accounts, that infringing rights of others is sufficient for forfeiting a right, right? So I infringe your right to life by trying to attack you in a dark alley, and that's sufficient, with a number of other conditions, to make me liable to defensive force, right? So I can forfeit my right to life by infringing or attempting to infringe your right. So if we accept that, then it must be the case that not infringing rights of others is a necessary condition for possessing the right against being harmed in that way, right? If we accept that you can forfeit a right by infringing the rights of others, then not infringing the rights of others has to be a necessary condition for holding the right. It follows from that that a person's interest in avoiding those harms is never sufficient for possessing the right against that harm. It's not sufficient because the necessary conditions also include not infringing the rights of others. So in central cases, therefore, possessing an interest in X is not sufficient for possessing a right to X. Now, interest theorists, of course, have long acknowledged that possessing an interest in X is not sufficient for having a right to X. So for example, I may have an interest in the $1,000 in your bank account, but that doesn't give me a right to it. So they don't say that possessing an interest in something is a sufficient condition for having a right. But the interest theory is committed to the narrower claim that where a genuine right exists, the right holder's interest in that thing is sufficient to explain why he has the right, right? As we just saw already, for Raz, it's part of the definition of rights that, and I quote again, an aspect of X's well-being, in other words his interest, is a sufficient reason for holding some other person to be under a duty. But the argument that I've just given shows that this claim is false. In the case of forfeitable rights, which remember are the majority of most rights, in the case of forfeitable rights, it is never the case that possessing an interest in the object of that right is a sufficient condition for possessing the right. That's because the absence of the forfeiture conditions function as a necessary condition for possessing the right. So, contrary to what Raz says, possessing an interest is never sufficient for possessing a right. Let's turn now to the second claim, the necessity claim. It's clearly the case that one can lose one interest in X without forfeiting one's right to X. Suppose I have some baby equipment. I have young children, so this is a very resonant example for me. Suppose I have some baby equipment to which I no longer need, now that my children have grown up. The equipment is used, it has no financial value, sentimental value, or option value for me. Indeed, because I have to find room to store all this junk, it has a disvalue for me. So if possessing an interest in owning the equipment were a necessary condition for possessing a right to it, then it would follow that I forfeit my right to the equipment when I cease to have an interest in it. Patently, I don't. Right? I don't have an interest in the equipment anymore, but I still have ownership rights over it. So the forfeiture principle shows that there are significant problems with the Razian account of the interest theory. Contrary to what Raz says, possessing an interest in X is neither a necessary nor a sufficient condition for having a right to it. Now, the reciprocity theory, in contrast, conforms to and gains support from the forfeiture principle. We've just seen that if the standard account of the conditions for the forfeiture of a right is correct, then it's a necessary condition for the possession of a right that one not infringe rights of others, exactly as the reciprocity account specifies that it is. Now, how damaging is this challenge to the interest theory? Well, one might argue that the force of the challenge is limited. So, I've shown that possessing an interest in X is neither a necessary nor a sufficient condition for possessing a right to X. But this doesn't show that the interests concerned are not the central grounds for possessing the right. Nothing prevents the interest theorist from accepting that compliance with the rights of others is just an independent condition for possessing a right. Similarly, just because some feature is a necessary condition for possessing a right, it doesn't follow that this is the most salient moral ground of that right. So consider an analogy here. One forfeits one's medal at the Olympic Games for failing the mandatory drug test. It follows that passing the drugs test is a necessary condition for possessing the right to the medal. But it doesn't follow that the right to possess the medal is most saliently explained by successfully passing the drugs test. Now, you might say that my claim that the right not to be killed is grounded in the reciprocal compliance with the right to life of others makes a similar kind of mistake to the mistake that you would make if you said that an athlete's right to the medal is grounded in his passing of the drugs test. It confuses a necessary condition for the possession of a right with a sufficient explanation of that right. Unfortunately, however, for the interest theorist, these comforting thoughts are not warranted. So we need to explain how the proposed independent conditions can be coherently integrated into a unified account of the possession and forfeiture of rights. All right, so if the interest theorist is going to say, well, it's just an independent condition for holding a right that you be respecting the rights of others. It doesn't really explain that, but it's just an independent subsidiary condition. If the interest theorist wants to make that claim, he needs to explain how the proposed independent conditions can be integrated into the remainder of the account. Without such an explanation, the account is objectionably ad hoc. In the case of the Olympics, we can provide precisely such an integrated explanation by invoking the conception of fair competition. All right? So the two conditions for having the medal, the condition of winning the race and of passing the drugs test, they appear independent and normatively disconnected. But when you think about it further, it's clear that they're not. They're in fact integrated at a deeper level. They are both complementary aspects of prevailing in a fair competition. Right? They're not just completely disconnected independent features. They connect at a deeper level through this idea of fair competition. So to account for the possibility of forfeiture, the interest theorist is compelled to posit two conditions for the possession of a right. The interest condition, which as we've seen is neither necessary nor sufficient, and the condition of complying with the rights of others, which is the very minimum necessary. All right, so he has to posit these two different conditions. But he can't provide an account of how the two conditions can be integrated in a coherent explanatory conception, given his underlying theoretical commitments. When an aggressor wrongfully threatens the right of a victim, he has no less an interest in continuing to live than at any other time. Why should the threat that he poses to the rights of others undermine his right to life when it in no way undermines or negates his interest in his own life and welfare? It would be as if, in the Olympics case, the athlete was stripped of his medal for failing the drugs test when the drug in question gave him no unfair competitive advantage. Right? It would be completely ad hoc. Such a forfeiture condition would be arbitrary because it's entirely disconnected from the underlying account of the appropriate grounds for the possession of the medal. In a similar way, the interest theorist can claim that complying with the rights of others is an independent necessary condition for the possession of a right, but he can't explain it. Right? He can't explain it in the context of a theory that sees rights as based most fundamentally in interests that are sufficient to ground complementary duties. So, can the reciprocity theory provide this deeper explanation for why the forfeiture conditions of rights, in other words, failing to comply with the rights of others, also provide, through their negation, the possession condition for rights, right? So what the reciprocity theorist is saying is that those two go together, right? You forfeit a right by wrongfully infringing the rights of others, and you possess a right precisely by respecting the rights of others. So in a very nice way, the two, in contrast to the interest theory, where those two conditions, as it were, diverge, in the reciprocity theory, they come together. But the question is, can it provide this deeper explanatory account, which I say is missing in the interest theory? Well, yes, it can. The explanation is provided by the principle that persons are owed respect and consideration because, and to the extent, that they manifest respect and consideration to others by complying with their rights, right? So this is really the underlying core principle that I think underlies all of this. Persons are owed respect and consideration because and to the extent that they manifest respect and consideration appropriately to others. And that provides the unifying explanation both for the possession conditions of rights and also for the forfeiture conditions. Now, this underlying explanation, this principle, I think, has a number of advantages. Let me just go through a couple of them. First of all, I think it's attractive in its own right. It links the possession of rights with the fulfillment of responsibilities in an intuitively appealing way. No rights without responsibilities. Second, the principle coheres with the logical structure of rights. As anyone who's ever read any Hofeld knows, claims, liberties, duties, powers, immunities, and so forth, all the Hofeldian incidents that constitute the domain of rights are all distinguished by a common feature. They all exist in correlative pairs of Hofeldian incidents. Now, this suggests, I think, that at the deepest level, the grounding of rights must lie in features of the relationship between the subject and object of rights, paradigmatically between right holder and duty bearer. Rights cannot arise independently of the normative status and agency of duty bearers and vice versa. The reciprocity theory is designed to give voice to this feature of rights, right? This fact that rights always emerge in these twinned pairs of relationships between duty bearer, right bearer, and duty holder. In this respect, the reciprocity theory contrasts strikingly with the interest theory, whose account of the grounding of rights is not interrelational but unilateral, right? So the interest theorist is only concerned with one party in the rights-duty relationship. It's all about the rights bearer and his interests. Doesn't really care, about the duty bearer. The duty bearer has to meet certain conditions. He has to have the appropriate resources to fulfill the rights, so his duties towards the rights bearer. But it's all about the rights bearer. Whereas on my account, on the reciprocity account, it's about both of them, and it's about the relationship between them. I think that's a really attractive feature of the account. So, reciprocity, I've argued, can provide a powerful explanatory account of central rights against harm. But what about rights to assistance? Now, you might think that reciprocity is not going to be able to say very much about rights to assistance, since those rights don't typically arise in relationships of symmetrical reciprocity, right? When I fulfill your right to assistance, it's very rarely the case that you're symmetrically assisting me. In fact, rights to assistance typically arise in situations of asymmetry of power, right? But reciprocity relations can, in fact, give a persuasive account of a significant class of rights to assistance. Consider a familiar scene from the life of a frontier community. Farmer John's barn has burned down, and the whole town has come together to rebuild his barn for him. The townsfolk recognize that they are under a duty to assist the unfortunate Farmer John. So suppose you ask one of those toiling away in the new barn, why are they obligated to assist Farmer John? Well, they might very naturally respond like this. They might say, well, look, he would do the same for me if it had been my barn. Now, what underlies this familiar form of moral reasoning is, I think, the following normative principle, and it's in essence a reciprocity principle. When a person acknowledges a duty to assist you in a given circumstance, this can generate a duty for you to assist them in comparable circumstances. In other words, duties of assistance can also arise out of relationships of reciprocity. The nature of the reciprocity relation underlying these rights is, however, different to that which underlies rights against harm. As we've seen, rights against harm arise from reciprocity in actual compliance, right? So I have the right that you not kill me because I am at this very moment respecting your right that I not kill you. But rights to assistance, on the other hand, don't derive from, as it were, a relationship of concurrent compliance. They arise from an expectation of future reciprocal compliance. And that's going to turn out to have really, really significant implications in terms of accounting for the differing stringency between rights against harm and rights to assistance. Now, so we have this hypothesis, right, that certain rights to assistance can be generated out of this kind of forward-looking reciprocity. Now, we can test this hypothesis by applying to it our old friend, the forfeiture principle, right? Because if it's indeed the case that a necessary condition for an agent to possess certain rights to assistance, that they acknowledge a duty to assist others in similar circumstances in the future, then those rights of assistance must be forfeitable in cases where the agent doesn't recognize the reciprocal duties, right? If it's true that these rights are being generated out of this reciprocity, then the forfeiture principle has to tell us that those rights must be forfeited in cases where agents don't in fact don't accept this future obligation, right? So we can test it by running it through the forfeiture principle. So what do we find when we do that? Well, when we examine cases, in fact, that's exactly what we find. So consider a number of cases. So I live in an area subject to very cold winters, right? So this is an example that should resonate with you here in Toronto. So I live in Toronto, but I can't afford a four-wheel drive car. And as a consequence, I'm always getting stuck in snowdrifts. And every time I do, my neighbor, who drives a brand new Land Rover, just drives right past me, you know, winding down the window and shouting out at me, "Get a real car, you bum!" Right? So finally, I save up enough money to buy a set of new snow tires, so I'm good to go on the snowy conditions. And the very first time I drive out with my new snow tires, I pass my my neighbor, who, having unwisely taken out his Ferrari instead of his Land Rover, is now stuck in a snowdrift. Beautiful. Now, although it would be generous of me to stop, right, it'd be a good thing for me to do, it seems pretty clear that my neighbor does not have a right to my assistance in these circumstances, right? I wouldn't be wronging him, I wouldn't be violating any of his rights if I just waved at him and drove past. His right to assistance from me is conditional on his recognizing a reciprocal duty to assist me in comparable circumstances. By repudiating this duty, he has forfeit his own right to assistance from me. So we don't normally think about rights to assistance as being forfeitable, right? But cases like this show that they clearly can be, and that they can be forfeitable in ways that are precisely consistent with the reciprocity account of rights. Now, one thing you might say is, look, okay, sure, in the case of trivial rights and trivial interests, like getting pulled out of a snowdrift, sure, maybe in cases like that. But surely that's not going to be the case in terms of very, very weighty rights, like the right to lead a minimally decent life, or indeed the right to life itself. Can it really be the case that rights to assistance of those much more weighty and significant rights can be forfeit in this way? Well, the answer is yes, they can. So here's an example to demonstrate that. So suppose my neighbor is a notorious anti-Semite. He constantly tells me that he wishes that I and my kind would disappear from the face of the earth. Now, he's a law-abiding citizen, right? He doesn't want to go to jail, so he will abide by the law. He will not threaten to attack me or harm me in any way, but he makes it clear that he will not lift a finger to help me, even if I'm in dire need. So one day, I'm out for a walk, and I pass him, and he's fishing by the canal, and he immediately launches into a hysterical tirade. He brandishes a document and says that he's just at this very moment come from his solicitor, and he's established a legally binding mandate that will prohibit any of his property, any of his agents, or any of his dependents from ever assisting me in any way, even if such assistance were necessary to preserve my life. Right? He's brandishing this document he's just signed at the solicitor's. And at that moment, he falls into the canal and starts to drown. And so here I am, I'm standing by the canal, and there's a life preserver right there. And I could throw the life preserver and save his life at no cost to myself. So what do we say about that? Does he have a right that I save his life? Now, it's very important to be clear about the different potential sources of a duty to throw that life preserver. Right? There are lots of different sources here. Perhaps the neighbor has children or other dependents who would suffer gravely if he died. So you might say, well, you have a right to his children to throw the life preserver. Similarly, it seems pretty clear that there are going to be virtue-oriented reasons for acting. To save the neighbor would be gracious and generous, whereas allowing him to drown would be petty, vindictive, and mean-spirited. Also, in purely consequentialist terms, there are pretty compelling reasons for acting. The goods that you could realize by throwing the preserver, not only saving his life, but also potentially bringing out a transformation in his bigoted attitudes, hugely outweigh the costs. So all of those reasons may ground a strong duty to rescue the neighbor. But the question I'm asking is a different one. If you didn't throw the life preserver, would you be wronging him? Would you be violating any rights to assistance that he has? And I say no. Right? I say no, you would not be wronging him by treating him in a way that he ought not to be treated if you fail to throw the preserver. By renouncing any reciprocal duty to assist me in comparable circumstances, the neighbor has forfeit his own right to assistance, even in cases of these very, very weighty rights like the right to life. Now, obviously, the reciprocity theory can explain why rights can be forfeited in cases like this. Certain rights to assistance, I claim, are centrally grounded in the recognition of a reciprocal duty to assist others in comparable circumstances. Where that recognition is absent, so too is the right. Now, I've argued so far that certain central interpersonal rights are best understood as grounded in reciprocity relations between moral agents. This theory, I've argued, has advantages over rivals in that it can better account for the dynamic nature of rights, the way that rights can be generated or forfeit by complying or failing to comply with the obligations that we owe to others. So I now want to explore a second really significant advantage of the theory. Its ability to explain the differing stringency between rights against harm and rights to assistance. So I said at the outset that rights against harm appear to be more stringent than rights to assistance in two critical respects. Duties to not inflict significant harm, such as death or severe attack, or severe attacks on bodily integrity, can be enforced through lethal means, right? So if you're about to kill an innocent person, I can step in and enforce the rights of that innocent person by killing you in self-defense or other defense. Secondly, duties not to harm can be enforced through acts of private self-defense, right? Because I can do that privately. I don't need to get the prior authorization of the government or of a court. Neither of those claims seems to be true of rights to assistance. But why? Why should that be so? It's certainly very hard to understand that on the interest theory of rights, right? Because the interests are exactly the same. Your interest in having your life saved through being of assistance is exactly the same as your interest in not being killed in contravention to a right against harm. So the interests are the same. Why should one of them seem to have this greater stringency in terms of legitimate enforcement rather than the other? Well, a familiar argument for why duties not to harm are more stringent than duties to assist is that the cost of compliance for the former is lower than for the latter, right? All that the duty to harm requires of us is to abstain from harmful action, whereas the duty to assist requires positive and often costly agency. Right? It's a very familiar kind of argument. However, this thought, I think, is both wrong and also misleading. It's wrong because fulfilling duties to harm can in fact impose very significant costs on the person who bears that duty. In fact, it can impose much greater compliance costs than can be justifiably imposed by a duty to assist. So think about a very familiar case, in case which you're being chased by a wrongful aggressor, and the only way that you can save your life is by using an innocent bystander. So, you know, someone is shooting at me, and the only way I can save myself is by grabbing Francois and using it as a human shield, and so Francois gets killed. Now, I take it that most people think that in a case like that, Francois' right to life is so significant that it requires me not to save myself at the cost of using him in that way. So I'm required to suffer the cost of death as the cost of complying with Francois' right to life. So in such a situation, observing one's duty not to harm the bystander requires the sacrifice of one's own life. The duty not to kill, or even not to wrongfully use a bystander, like in a case like that, is so stringent that even where the right bearer is a stranger, it can generate a duty to suffer death as a cost of compliance. Now contrast this with the sacrifice that can reasonably be required to fulfill a duty to assist a stranger. It's very difficult to imagine any circumstance in which a duty to assist a stranger could require the sacrifice of one's own life, right? Maybe you can be required to give a certain amount of money, give certain of your possessions, maybe go out of your way, but to give up your life as a cost of saving a stranger, it's very hard to imagine a situation like that. So this example shows how misleading this traditional account for why rights against harm are more stringent. In fact, you know, the traditional argument, remember, says, you know, the compliance, the costs of complying with rights against harm are much lower. In fact, precisely the opposite is the case. In fact, rights against harm are capable of imposing much higher costs of compliance. The capacity to impose these higher compliance costs on duty bearers is in fact one of the important features of the greater stringency of duties not to harm. So the challenge is to explain why, right? Why this is the case. Why is it reasonable to impose higher costs as a price for complying with duties not to harm compared with duties to assist? Right, so that's really the challenge. Now, the reciprocity theory, I think, meets that challenge. The reciprocity theory has a very simple explanation for why you are required not to kill the bystander, even at a cost of having to sacrifice your own life. Right? You owe the bystander the consideration of not killing him because he is extending at that very moment the same consideration to you. Right? He is at that very moment respecting your right to life. And that is something of immense value and importance to you. So he's doing something for you at the very moment that you are required to bear those costs. That's why you owe him the reciprocal duty. So the highly stringent nature of rights against harm is linked to the distinctive character of the reciprocity relations that underlie them. As we've already seen, rights against harm are grounded in a reciprocity of actual compliance, actual concurrent compliance, right? You are complying with my right at the very moment that I'm being required to comply with your right. Now, the reciprocity relations underlying rights to assistance, on the other hand, have a very different character. Rather than being rooted in a reciprocity of actual concurrent compliance, they instead are typically stem from a reciprocity of recognized obligations for future compliance, right? So we've already seen most people that we are called on to assist are not currently assisting us, and nor have they assisted us any time in the past. Instead, the obligation to assist arises from the fact that they are now acknowledging an obligation to assist us in comparable situations in the future. Right? Remember the farmer? He would do the same to me if it were my bum. It's not that he's helping me now, but he would do the same to me if I were in the same situation. So the reciprocity here is different to the reciprocity we find in the case of rights against harm. It's not concurrent, but it is prospective and conditional. So it grounds a duty, yes, but it lacks the stringency that derives from the reciprocity of actual compliance that we find underlying rights against harm. So the difference between the two, I think, is both an epistemic difference and an ontological difference. So ontologically, it's a matter of objective fact whether you are currently complying or failing to comply with my rights against harm, or whether you've done so in the past. Right? That's a matter of fact. And moreover, I can know with near certainty that you are all here today currently complying with my right to life, because it's quite obvious that you're currently making no attack on my person. but it may be impossible, even in principle, to determine whether you will assist me at some point in the future, since this depends on your future free decisions. Certainly, I can know your preparedness to assist me in the future with a much degree of certainty than I can know your current or prior compliance with your duty not to harm me. Have I got a few minutes more? So, the reciprocity theory can explain the different stringency between the rights. So, I think the reciprocity theory can explain the differing stringency between rights against harm and rights to assistance. Right? The differing stringency derives from the different kind of reciprocity that underlies the two different forms of rights. But not only can it do that, it can also explain why identical interests can sometimes generate different duties to assist in different classes of agents. Again, something that the interest theory has a great deal of difficulty explaining. So let me give you an example. Intuitively, it seems that we have stronger duties to assist those with whom we share special relationships than we do to assist strangers, even when the needs are the same, right? So if my child is mortally sick and a stranger's child is mortally sick and I have one dose of medicine, it seems like I can give the medicine to my child and not give it to the stranger, and that I have a stronger moral reason to do that. The child has a stronger right to assistance than a stranger does. Even when the needs are the same. Now, this makes sense from the perspective of reciprocity. On this theory, the strength of the duty to assist depends on the reasonable expectations of future reciprocal assistance in comparable circumstances. But that in turn depends on the strength and depth of social relationships. I know with great intimacy what forms of support and assistance my close friends and family can provide to me in moments of need. This knowledge guides and supports the interlocking obligations of care and consideration that are partially constitutive of friendship and familial ties. That is why duties of care for friends and family are so strong. With strangers, I have far less reason to believe that they recognize and are ready to act upon a stringent obligation of assistance towards me in comparable circumstances. Right? That's why we find differential stringency of obligations to assist, even when the interests are the same between people who are close to us and people who are strangers. Nonetheless, obviously, we can have duties to assist strangers. Most obviously, we have strong duties to assist strangers who are compatriots through participating in public welfare institutions. Now, the reciprocity theory can explain these duties, and moreover, why these duties can be stronger than duties that we owe to non-compatriot strangers. The explanation goes like this. Legal regimes can play a decisive role in enabling duties of assistance between strangers. Legal regimes play a decisive role. Once a duty to assist has been legally enforced within a legal regime, for example, through a compulsory social insurance scheme, that very fact provides a strong reason that otherwise would not exist to expect that others within that regime, so my co-citizens, will contribute towards assisting me should I be in need. Right? I know that others within my other citizens within my country will assist me because the law requires us all to pay into a shared social insurance scheme. So I know even someone I've never met on the other side of the country, they're a complete stranger to me, but we're bound together by this legal regime that gives me confidence that they will in fact assist me in a comparable sense in the future. So this explains why duties to assist can be justifiably enforced through public institutions like social insurance schemes. This is the neat part. The mechanisms of enforcement here, right, the legal mechanisms of requiring people to pay in, is itself partially generative of the very duty that it enforces. Right? The very fact of legal enforcement generates the moral obligations that it is, in fact, itself enforcing. So that's to say, by making it the case that my compatriots will, in fact, assist me in moments of need, legal enforcement generates moral obligations for me to contribute towards provision for their need. This fact, in turn, explains why, other things being equal, we have greater duties to assist compatriots than we do to assist foreigners. The reasons have nothing to do with metaphysical notions of blood and identity. It is rather because of the very concrete way in which law enforces prospective reciprocity among members of a community and thereby generates duties of assistance between them. For strangers who are not compatriots within a shared legal framework, the basis of expected future reciprocity rests on something more tenuous. a kind of shared presumptive understanding of common humanity. Now, I don't want to minimize that. That's a really important thing, right? We rightly assume that most people are prepared to assist others in cases where the need is very high and the costs of assistance are low. To be sure, I can't be certain that all persons will recognize such an obligation, and clearly some do not. There are sociopaths and people who just absent themselves from the moral community. But knowing what I do of humanity, both in myself and in others, it's a reasonable presumption, at least until defeated by further evidence, that a stranger that I meet with whom I share no legal institutions will in fact recognize some kind of an obligation to help me in situations where my need is great and the costs of assistance is very, very low. So there's a defeasible presumption, I think, that we all make, and a completely accurate and warranted one in most cases. It's a defeasible presumption is sufficient to ground a duty to assist. And the shape of this duty, I think, conforms to the intuitive shape of our duty to assist strangers with whom we share no publicly enforceable institutional arrangement. That is to say, we have the duty to assist in cases where the need is great and the costs of assistance are low. And in fact, that intuitively, that is where most people would put the requirement to assist strangers who are not compatriots in this way. So let me just very briefly wrap up. Reciprocity theory can explain a raft of commonly held intuitions about the stringency and behavior of rights and duties. Duties not to harm are extraordinarily stringent, and they are so stringent because they derive from reciprocity in actual compliance. Right? You and most people in the world share a reciprocity in the sense that we are both mutually complying with each other's rights against being harmed. Duties to assist are weaker because they're grounded in expectations of future compliance. They're weaker still when social relations are tenuous and there is no shared legally binding enforcement mechanism. The same family of considerations explain why duties not to harm are privately and lethally enforceable in cases like self-defense, whereas duties to assist typically are not. The global boor can have rights to assistance from the affluent. Certainly that's correct, but those rights have a different character to the rights against harm that can generate rights of lethal private defense. When someone makes an unjustified attack on your life, they attempt to kill you at the very moment that you are complying with their right not to be killed. The stringency of the duty explains the exceptional permission to enforce the duty through private lethal defense. Let me leave it there. We can go to discussion.
Well, thank you very much for very thought-provoking papers. I know that it was thought-provoking. We already have a question. Gary.
Thought-provoking and question-provoking.
I'm getting this out now because I've got my own parental duties to attend to at the moment, so I want to...
Oh yeah, we have to use the microphone.
Yeah, sorry about that. So I'd like to thank you very much. I really enjoyed the paper. It hit a lot of my own sentiments and my own conclusions. And there is a couple things that I wanted to mention, and I guess the first one is, does the reciprocity theory just basically collapse into a rational choice contractarian via Gautier? And I think it does to some degree, I mean, at least on a meta level. And if that's the case then I think we can follow you through to the compatriot argument. But I think once you get to this conception of humanity on the international level, you might want to take as an approach more so a market-based approach, such as Gautier does, right? To think about the interactions on a market level, and to think about the extent to which, if the global market is continuously growing, and we sense in that sense we have these interconnected market transactions that occur, then perhaps we can sort of get that duty going on a reciprocal basis, as opposed to just saying, well, it's our humanity, it's our shared humanity, right? And I think you can still continue with that reciprocal notion in a much stronger sense. And so I'm wondering whether or not you've considered that on the Gautier level and considered that through looking at it on a market basis as well.
Thanks. So on the market mechanisms, no, I haven't looked at that. I mean, there will be some interesting things. Let me just give a couple of comments about whether this collapses into a kind of contractarian Gautier type theory. So I don't think that it does for this reason. So Gautier's argument is that we can understand moral obligations as essentially a form of extended self-interest. Right? Yeah. That's not the assumption that I'm making in this account at all. Right?
Okay.
And in that sense, it doesn't seek to provide the kind of explanation that Godey is seeking to explain of why morality should be seen as rational in that perspective. So I started to level up, right? To buy into this theory, you already have to believe that there are certain kinds of genuinely moral obligations. But I think that they're very, very thin, right? And I think that they're essentially, as I put it at a number of points in the paper, they're obligations of reciprocity. At its most basic level, the obligations, and my starting point is that there's an obligation to give respect and consideration to those who give appropriate kinds of respect and consideration to me. So the starting point is different in that sense, and it's an already moralized starting point.
Okay.
So it's different from the Godey project in that respect, but obviously it has certain kinds of overlap and some similarity, absolutely. And so what's crucial about that is I think that certain kinds of objections to Godey's project I can avoid because I'm starting kind of a little bit higher up that normative tree. So I don't think that everything has to be, but on the market stuff, no. I mean, it would be interesting to look at that and see whether there are useful things that I can kind of take from that. I can
send you an email because I have a paper on that as well as
Perfect.
some thoughts on it. So, sure.
Mano, microphone.
Okay, I found the theory very interesting. But there was a part of it that I just couldn't get over, a problem that I found as I was reading it over. So it's a relational theory of rights. I have rights insofar as I don't violate someone else's. So if I violate someone else's, I lose those very rights myself. Right. So doesn't the legitimacy of the theory rely on that enforcement of rights proportionality? So if someone violates someone else's rights, their rights have to be violated in turn. Or they have to lose their rights. So first I wonder, how would you assess that concept of risk, of harm? Because in the one example of the anti-Semite one you had mentioned, that was a foreseeable risk. That was something that was to happen, correct? It wasn't something that had happened yet. It was an assurance. So I found like the idea of risk seems to be central to it, where that person forfeited their rights by virtue of having posed something to you, potentially. And I just found that the concern of that the legitimacy relies on the violation of rights for it to be upheld being a very big concern.
Okay, I'm trying to put my finger exactly on what the concern. So let me just pick up on one thing that you said. I just want to clarify that this is, so you said that my theory relies on the idea that someone who violates rights has to have rights violated in turn. I don't think that that's quite right. In this sense, so there are two ways in which you could cash out notions of loss of rights or alienation of rights. So one way that you can cash it out is through an idea of desert, right? Where you say, if you violate rights of others, then it is actually a positive good that your rights be violated in turn. So this is the kind of retributivist idea, right? That's not the idea that I'm trying to invoke here, and in fact I find that a repugnant idea, and I think there is absolutely no moral warrant for that. So the alternative way that I want to cash this out is in terms of liability to harms, right? So what we say is that by wrongfully infringing the rights of others, it's not that it becomes a positive good to harm you, but that the protections against harm that you used to possess in terms of your rights become suspended insofar as harming you in that way is necessary to rectify the wrongful act that you've undertaken, right? So it's different from so the liability approach is different in that it doesn't say that somehow it's a positive good to inflict harm on them, or that you restore balance to the moral universe by harming those who have harmed others. It simply said that by wrongfully harming others, you lose the rights-oriented protection against being harmed for the purposes of rectifying the wrongful act that you've already undertaken. That's all it's saying. It's a much more limited. So I don't know if that helps in terms of the wider worry, but
because I found in one of the examples you had said was that if someone saved someone else's life, the person whose life was saved ought to save that person's life in turn, should it come up.
Right. That they would have a stronger duty to assist than would otherwise be the case.
But
right.
Wouldn't that work in the inverse? If someone kills someone else, then they ought to be similarly, but by the same token, right?
Well. But I take it does, right? Well, you have to give me the concrete case that you're thinking about.
So So let's say the person down the street runs over somebody that I care deeply about.
Okay. Wrongfully.
Yes.
Yeah.
So by the theory, I would have grounds to do the same to that person.
Well, you would, and so I mean, so if you could, if you could kill that I mean, if you could do so preventively as a matter of self-defense, yes, you absolutely would. So if you're standing there with a gun and you could shoot the driver to make him avoid your loved one, clearly you would have the right to do that. So look, so there are three different contexts in which we can think about rights being affected by wrongdoing. There's the defensive context, which is the one I've just described. That clearly is the case. After the fact, there are two other ways in which rights can be alienated for the purposes of rectifying the good. One of them is the restitution case, right? So you can say, well, what harms could you inflict on that person to make good the wrongful harm that he's inflicted on your loved one? So clearly, he would be liable to making some kind of financial compensation or restitution. Beyond that, I mean, it's, killing the person. So, one case you could think about, he wrongfully runs over your loved one, doesn't kill her, but makes her mortally wounded. And the only way that she can be saved is by harvesting an organ from the driver. Would he be liable to have his organ harvested to save the loved one? I don't know. Maybe, I don't know. Yeah. So we think about the restitution context. So, and then the final one, of course, is the punitive context, right? The punitive context. So the punitive context is somebody goes out and murders. Can you punish that person by killing him? Now, I don't think that you can, but a challenge for someone who believes in forfeiture of rights is to explain why so the possibility, right, the possibility is not ruled out by a forfeiture account of rights, right? So, a justification for the death penalty clearly can be made within a forfeiture account of rights, and has been made within a forfeiture account of rights. So in neither context does it seem, there are familiar examples of that kind of mechanism at work. We need to debate about what are the concrete limits of that. But in all of those cases, we find that, exactly.
Michael.
So hi, Professor. Thanks for that talk. And I think it addressed a lot of the issues that we were dealing with in the class about limitations of certain theories of rights. And one thing that I thought was interesting, and I know that you were trying to explain the theory and you have a lot of time to deal with the limit or the trouble cases. And one of them that I was hoping that we could talk about a bit more was, I guess, the two things that you touched on in the paper. I don't know if you can expand on them. One of them being like the case of institutional rights, because I guess you could extend the reciprocity theory a bit further in terms of like ultimate like duties of citizens towards the state. But for example, rights of the state to provide either positive, I'll use the Canadian lingo, but the positive or negative rights to its citizens. The reciprocity theory, I guess, I think you refer to it as institutional rights. I don't know if you've kind of given it some more thought since you wrote the paper in terms of how that would work per se. And also about, I guess, certain way we would call, I guess, inalienable rights. For example, where reciprocity doesn't go there. Like, for example, under the UN Declaration of Human Rights, everyone has a right to blank, right? There's no way you can alienate at all. There's no reciprocity. There's no way you could forfeit the right, even if you yourself don't respect it. Immunity from torture, and I know you do talk about it a little bit in yours. For these inalienable rights and so-called institutional rights, I don't know if you've given some further thought. I was thinking myself, you could for institutional rights maybe extend the reciprocity theory, on a higher level in terms of duties of citizens and whatnot. But I don't know if you had thought about it since, and if you might want to share some of your thoughts about those two.
Yeah, good. So no, I haven't made a lot of more progress on the institutional rights. So my gut feeling is that this kind of theory, it's going to work best, and its natural home is in the context of what I call these interpersonal rights, right? So rights between agents that can be mediated by institutions, but where we can make sense of them existing in a state of nature, right? Where there are no institutions whatsoever. So that clearly is the kind of the basic rights of security of the person and basic rights to assistance. We can understand those making sense and existing within a state of nature. I think that some institutional rights can be informed by this kind of account as well, and so I talk about rights that we have corresponding to social insurance schemes. But beyond that, I don't know. So it's a project, right? It's going to be a project of So the way I view this is I start at the core. I make no claims that reciprocity can account for all rights, even necessarily for all moral rights. So I want to be very clear about what the ambitions of this theory is. It's not an account of what rights are in terms of just a kind of an analysis of the concept of rights, but neither do I take it to be an account of what rights there are in terms of providing a set of necessary and sufficient conditions for the possession of rights. What it's supposed to be is a normative explanatory account, by which I mean for a class of rights, I can tell you why agents possess those rights, why they present in the way that they do, so why they have the stringency they do, why they are capable of imposing particular kinds of duties and obligations on other agents, and why they can change their configuration through processes of alienation and forfeiture in the ways that they do. That's the kind of account that I'm trying to give. And again, in terms of the domain, I don't think that this is going to be able to give an account of all rights, or even necessarily of all moral rights. But yeah, in terms of the strategy is to start with the core and then expand out and see how far I can take it. Now, on the inalienable stuff, so I think this stuff is really interesting. So people will often say that, so human rights, you look at the preamble to the Universal Declaration, it says right there in the preamble, these rights are taken to be inalienable and possessed merely by the fact of being human. That just turns out to be gosh, right? Most of those rights are not inalienable at all. They can be alienated in all kinds of ways. And moreover, the possibility of alienation is one of the crucial ways in which those rights protect, right? The possibility of alienation in the context of forfeiture mechanisms like defense, like compensation, like punitive action. Those are core ways in which rights function to protect people, right? So alienation is part and parcel of the way that most rights function, and it's critical to the kind of protection that they give. But now the question arises, is that the case of all rights? Are there certain rights that are purely that are completely, literally inalienable, unforfeitable? So, the candidates that are often mentioned are the right against torture, the right against slavery. I'm trying to think what's the other. Those are really the two key ones. So one thing I say is I do think that there is an absolute prohibition against those practices, but it's crucial to realize that an absolute prohibition and an absolute right, in other words, an unforfeitable right, are not the same thing. So it could well be that there are overriding moral reasons not to torture, even if it were the case that a person had committed crimes so egregious that he no longer possessed the right against being tortured, right? So what we might say, and I think that this is probably actually the thing we do want to say about certain kind of contexts, we might want to say, even though this person has done acts that are so horrendous, he's tortured infants, and that he doesn't have the right against being tortured, but nonetheless, there are other reasons, other very powerful reasons for not torturing. And in fact, I think that we can say that in the case of torture. I think that these have to do with much more agent-related reasons of the kind of agents that we want to be and the kind of values that societally we want to have binding upon our law enforcement agencies. I have an unpublished paper on exactly this point. So I think that's probably what we're going to end up saying about things like rights against slavery and rights to torture. We'll say that they are not necessarily impossible to be forfeit, but even in cases where they are forfeit, there are overriding reasons for not treating them in those ways. They just don't have to do with rights. Now, I think that there's another interesting class of rights where that may not be the right kind of account. And this arises most clearly in the case of due process rights, right? So due process rights say, well, those are just inherently institutional, so they don't come within this forfeit, within the. But I think, I think what's interesting about due process rights is that they're, in a sense, they're meta rights, right? So they're rights that are there to ensure that your other first-order rights are appropriately protected. And it seems to me intuitively that there's something special about that status which might give them that unforfeitable status.
Justin had a question on point.
Yes. Now that I have the microphone, this is good. I had a question relating to your discussion of the reasons behind, certain punitive action, whether or not they are related directly to the right. I was wondering if the reciprocity theory can take account for the magnitude of the stringency of the rights that we possess, not the different stringency between the right to harm and the right to assistance, but within rights within those groups themselves. It seems to me intuitive that we hold rights to have differing import or value to us, and I was
Right.
wondering what sort of reasons or justifications there are for these differences within the reciprocity theory, or if they are necessarily external to it.
Right. So I can defend myself against your wrongfully killing me by killing you, but I can't defend myself against your punching me in the nose by killing you. That's the kind of case that you're thinking about.
No, I'm thinking about why we think that our right against being killed is more important than our right to free speech or something to that effect. Why certain rights that we hold are of greater import to us? Are they necessarily subjective? It's just the right that I value more. Is it objective, something that we can weigh independently, or is it entirely contingent upon
Right.
the society in which we've grown up?
Right. So so I do at one point in the paper have a kind of short aside where I say that that even on a reciprocity theory, interests are not going to be irrelevant to rights and to the way that they perform. So one of the functions that interest has is that it informs notions of proportionality, which I think are one of the key components and indicators of this differential kind of stringency that you're talking about. So, right, so because one of the ways that one of the significant features of the differing stringency between these different kinds of rights is that there are very different proportional means that one can use to enforce them or to regulate them, either through punitive action or defensive action or whatever it may be. So proportionality, I think, is going to directly invoke these notions of interest, right? So even though a trivial right and the right to life, they may both be emerging, on my story at least, out of this kind of concurrent reciprocity. The trivial right can't be defended or result in punishment of a comparable level to the other one because because the interest that it's protecting is that much less significant. So I think that they play a role in that component of it, for sure. So I do think that they play that role.
I guess I have a question about the. Oh, do you have a question? Why don't you go first?
There's something to the reciprocity theory which feels a bit, a bit cold. I'm trying to figure out how to, an example to try and work with it. So I guess even with a focus on interpersonal rights, so leaving for aside institutional environments and considerations, a couple of the examples that you give almost set up and color the kinds of intuitions I think that we have. So I've got in mind your neighbor who's driving the Land Rover and who's quite explicit about not being willing to help you if he sees snowdrift, and the anti-Semitic neighbor also who's quite clear in their unwillingness to assist you if you were needed. But I guess there are other cases where I could see an interest theorist coming back and saying, well, reciprocity is not going to explain rights in other interpersonal situations. So suppose that on the way home from work I see Francois and he's drowning. And it wouldn't take much at all for me to throw him a life preserver, or suppose I'm an exceptional swimmer and I can dive in and get him and save him. But I also know that there's no way, for whatever reason, he would ever be able to reciprocate. Not that he wouldn't want to, or that he dislikes me and he'd hate to provide me any assistance. But I just know maybe he's too weak. He could not jump in and save me if I were drowning, or he's physically incapable of even sort of nudging a life preserver into the river to save me. So suppose
because he's a paraplegic, for example.
Right.
Yeah.
My example better.
Yeah.
But suppose I know epistemically that there's just no way he's going to be able to reciprocate. And yet still he's got a crucial interest in being saved by me. I'm the only one around who can provide assistance. And on just about any moral theory that we might think of, we'd say, well, that interest he has is sufficient to ground a duty, even though he'll never be able to reciprocate. So reciprocity's not even there. Now, I'd agree it'd be a virtuous, a kind, a generous thing for me to do to jump in and save him. But it also seems like the interest theorist would say, and and he's got a right that you provide that assistance. I'm just wondering what mistake have I? Because I like
good.
reciprocity theory, but
Good.
I'm just not sure about those particular cases.
Yeah. So here I think is one way in which my theory differs from something like the Gaudier theory, and in a way that's superior, that better handles cases like this. And just reading through the paper again yesterday on the plane over, and again today, actually realizing that some of the language that I use in this part of the paper is perhaps not precisely what I want to say. So in the paper, I kind of suggest that it's very natural to read it in the way that you have, to say, look, it's based on future expectations of what this person will actually do, right? That he will, that he may actually assist me at some time in the future. I don't actually think that is the correct way of putting the thought. So start with the original formulation of it, right? So the guy says, look, the guy building the house, he says, I ought to help him because he would do the same for me if he were in my circumstance.
It's counterfactual.
Right, it's a counterfactual, that's exactly right. So the question we're asking is not, will he do that for me in the future? Or even, is he in a position materially to do that in the future? But what we're asking is, if he were in my situation, with my resources and my abilities, would he in fact assist me? Now, if that's the way that we're conceiving of what's generating the obligation here, then it's much friendlier to those kinds of examples, right? Because we're not saying, he's poor and he's never going to be able to help me in any time in the future. That's the kind of problem that Gaudier has to worry about, right? Because Gaudier, it all has to come back to self-interest. But I'm starting from a different perspective. I'm starting from an already moralized conception of how duties arise. And the assumption I'm making here is that if that counterfactual is true of a person, so in other words, if it's true of that person that he would in fact help me in this similar situation, then I ought to help him in that situation. So that helps with situations like the paraplegic drowning person. It helps with people like assistance to the poor who will never be able to help us in the future. And it even potentially lets us give an account of how we can have obligations to those far in the future. Because obviously those in the future, as the old joke goes, why should we help future generations? What have they ever done for us, right? But on this account, on this telling of it at least, you don't have to say that. The question we're asking is, are there reasons to believe that they would, in fact, treat us with those kinds of respect and consideration? So I think in that sense, yeah, it's in a much better position than the kind of Gaudier versions of.
Could you? Now I'm curious about. Is there any room for sort of revising or rationalizing the beliefs that other person might have? So suppose you have the neighbor who drives past you every time you're in a snowdrift and is quite proud not to help you. And you think, well, this time you see him in his Ferrari in the snowdrift, and you think, well, if he were thinking correctly about what he owed to others, then he would, in fact, help me were he to see me in a snowdrift. I mean, is there any room for imputing better beliefs or better intentions or actions for others?
Well, look, so let me first.
Not that I want to save the Ferrari driving person in the snow.
Okay, so let me first say, so one thing is, rights are, very obviously they're not the whole of morality, and they should never be confused with the whole of morality. So when we face kind of real questions, policy questions, policy of action about whether we should help someone or harm someone, rights are only going to be one component of that question. They're going to be all kinds of other considerations, consequential considerations, virtue considerations, considerations of humanity, all of those things. Now, I take it that the function of rights is a very, very specific and peculiar one, right? So the rights are, they're essentially mechanisms for solving very particular kinds of normative challenges that often have to do precisely with reconciling interests in situations of interpersonal conflict. Rights are very, very good because they provide doing that because they provide this very, very structured kind of way of resolving those. But we should never confuse it with with the whole of morality, with all of those much richer set of considerations. So in response to that, if you say, well, couldn't you build in this idea not only of what their actual, as it were, disposition is, but what their kind of ideal disposition is? I think that the account that I give of it is much more congruent with the kinds of functions that rights actually play, in the sense of I think that it's I think rights critically are about relationships between particular persons. So in that sense, I think the account is. It's very different to the golden rule account, right? So the golden rule account says treat others as you would have them treat you. What I think's distinctive about rights is they say treat others as in fact that other person. So others are deserving of consideration that's congruent with the consideration that they're prepared to give others. That's what I think is the kind of distinctive principle that is underlying and best explains the kinds of normative configuration and the kind of normative work that rights perform. So it's not to say that other, that the question that you're posing, the golden rule poses, is morally and normatively irrelevant. Obviously it isn't. And it's really important to ask those kinds of questions. But the claim is just that it's not necessarily the right question to be asking when we're thinking about rights. And what I mean by that is it seems that it's not going to give you, it's not going to explain the kinds of outcomes that rights reasoning gives us in situations like these.
Okay, David, could you expand on this idea of respect, which seems to be at the core of your account? You seem to say we acquire rights when we respect the rights of others. Because I hear you saying many things here, and maybe you have a plural idea of what respect means, but then I just want to be clear on this. On one hand, you just say, well, I respect others when I'm prepared to respect their rights. I can assess somebody's respect for my rights in terms of what they would do if they were in my circumstances, so counterfactually. And I respect other people's rights when actually in what I do, irrespective of what I'm thinking, I am not violating their rights. Right? So I'm thinking of a situation, for example, like the bystander situation, when I use X as a shield, an innocent X as a shield against Y attacker. He's actually not attacking me, he's not challenging my right, but in fact this person despises me. Yeah, it happens that the person despises me, and in fact could even have been planning 10 minutes later to kill me, but at that very point they're complying with my rights. And then the flip side of this is somebody who is only helping me, assisting me, because they're under some sort of delusion, right? So what is it that grounds the account? Is it either of these three? Is it the three together? Do we have a unified theory?
Good, great. So look, what I think is going on here is that we essentially have two different notions of respect in play here. So let me just first of all clarify the relationship between the intentional component, so the preparedness component and the counterfactual component. So what I would say about that is that the intentional component, the preparedness component, the recognitional component, right? I recognize an obligation to help you. I think that's one subsidiary component of the counterfactual, right? So one of the ways in which we establish that the counterfactual is in fact true is that we point to these intentional facts, right? You say, well, given what we know about Francois, given what we know he's done in the past, given what he's written in his papers, that's good reason to believe that the counterfactual is in fact true. So I think the intentional components are subsidiary to the counterfactual in that respect. I think the real distinction is between the counterfactual running of this and the compliance running. Now, let me just also pose one kind of further wrinkle or difficulty with it. So, the compliance condition, which I say is the one that's operative in these rights against harm, the compliance there turns out to be very, very minimal, right? So you said it has to do with what you do. Well, it often has to do with what you do, but not necessarily. So think about problematic cases like incompetence, right? So, my neighbor has, he's gone into a coma and he can't do anything, right? But he still has the right to life, presumably. I would wrong him if I went over and unplugged his life support system. So how can I explain that on my reciprocity account? Well, the way that I explain that is I say, look, he is giving me the respect and consideration that he ought to give me in a way that grounds my reciprocal obligation to give him that respect, merely by complying with his negative duties not to kill me, right? So what I say about this case is, well, we can make sense of that because we can say my neighbor is the kind of being that can possess rights, is a human being, that can possess duties, right? It's a human being, he can possess duties not to harm me. And moreover, he does possess duties not to harm me, right? He, at that very moment, while he lies comatose in the bed, he is under an obligation not to harm me. And in fact, he's complying with those duties, right? Now, it's the case that he couldn't do otherwise, right? He couldn't actually kill me even if he wanted to. But I said, but that doesn't matter. He can possess duties, he does possess duties, and in fact, he's complying with those duties. And that's sufficient to make it the case that I have the reciprocal obligation not to kill him. Even
if you knew that this person
right, even if you
were
knew,
he not
right,
comatose to kill you?
exactly. Now, so obviously so obviously those two can come apart, right? So in the actual compliance case, he can be complying, but in the counterfactual case, it may actually go the other way. So what I think I have to say about this is that yes, indeed, that is the case. These are indeed two components of it, but the actual compliance is the more stringent of the two. Now, why? Now,
why is the question?
Right. So one question is one question is whether that's true, and the other question is why that ought to be true. Now, I kind of only just started to think about this, so I'm not sure I got to the bottom of it. But I was thinking about how these kinds of considerations seem to play out, for example, in sentencing considerations. So think, for example, about the case of a repentant criminal, right? So we know that he did the crime, right? We know that he did, in fact, fail in his obligations, right? But he's now repentant, right? And we now, so in terms of the actual compliance, he fails the compliance test. But in terms of the counterfactual test, so if we say, this person now, if he were in that situation again, would he do that again? And we say genuinely no, he's a repentant, he's a changed person. And so how do we deal with that as a matter of sentencing? So now I don't know whether this kind of analogy works out perfectly or how it would go, but it seems kind of we do make that trade-off in sentencing, right? We say, yeah, he's liable to be punishment, but the fact that on the counterfactual basis he wouldn't actually commit the crime, that moderates his liability to punishment in some respect.
Well, but the idea that he's committed a crime entails, well, if we use the common definition of crime, that there was some sort of subjective intent at that point.
There,
right?
absolutely. At that time there was the intent, absolutely.
Right, okay.
Absolutely, at that time there was the intent.
But no more.
So yeah, so I don't know. I mean, but so it seems to me that in cases like that, we may actually be doing a comparison or a normative weighting between divergent forms of that two tests. But I think I need to think more about that and how it really plays out in these concrete circumstances.
Especially if you're going to say that, Hitler just happens to be comatose, right? At the time where, so that's the problem.
At the time where, so what?
At the time where we're asking the question of compliance with the rights. Anyway, we can talk about this after, because I know there are a lot of questions. So Sam first, and then we're going to go here and there.
So I'm happy to hear you distancing yourself from Gauthier, contra Garrett. And I suppose we're getting away from grounding a duty to assist in the actual potentiality that such assistance would be reciprocated. It seems like we're moving to this idea that the potentiality ought to be in normal circumstances, or say in my circumstances, right? And this would seem to bring us to, say, a metaphysics of universalizability or normalcy. There may be some trouble there, but I'm not too worried about that. What strikes me is that this seems to be shifting the moral bases of rights away from reciprocity and towards a capacity for reciprocity, right? And I'm happy if that's where you're going, because that seems to me a richer basis for rights. What we're looking at is something like, a capacity for rational agency, and this is what grounds our duty to others. Was that what you had in mind?
I'm not sure that it has. So, I said in a number of points that I think that it's wrong to view rights as being possessed purely on the basis of being humans. But I think what is right is that we have the capacity to possess rights purely on the grounds of our humanity. And part of the reason for that is that we have the capacity to engage in these forms of reciprocating relationships. And part of that, of course, does seem to imply that we do have these capacities of agency and so forth. So to that extent, that yeah, those are all going to be necessary features of getting the story running. But what I don't want to say is that what I don't want to say is that along the lines that some theorists say is that rights are possessed because they are necessary to preserve the agency of some kind of conception of our agential capacities. I don't think that's the case, because I think where the rights come from is from our actual reciprocation. So the capacity to reciprocate is a necessary requirement for that, but we don't get the rights just because of the capacity. We get the rights because of our actual reciprocation.
Okay, so maybe I was too quick in interpreting you of leaving Gautier behind and embracing Kant, for instance. So we're still looking for the actual potentiality to reciprocate, right? So we still have problems, I think, with the paraplegic.
Well, so what I said about the paraplegic is that the test that we're applying is he a being capable of possessing rights, which on my account is going to be roughly equivalent to the test, is he a being capable of engaging in reciprocating action, right? If that's the case, which is clearly true of the paraplegia, right? So he has the agential qualities that makes him possible to engage in these kinds of reciprocal relationships, right? He doesn't have the physical capacities to fulfill an obligation to assist, right? Because he can't move his body, but he has the agential capacities, right? He can engage in relationships of reciprocity in all kinds of non-material ways, right? He can be kind when you're kind to him. So he has the capacity. He has those kinds of agential capacities for reciprocation. So what I want to say is, if he has those capacities, the test that we apply is we say, if the situations were reversed, right? So he, agent, were now in my body, and me, agent, were in his body, would he, agent, right, given what he is and who he is, would he reciprocate in that situation? That's how I'm taking the counterfactual test to be. So it's neither the Kantian test nor the Gautier test.
Yes. Oh, yes, the microphone. Thank you for your diligence.
I'm wondering if you could say more about how a reciprocity theory, or your theory specifically, is sort of a rival or competitor to the interest theory. Because given what you said earlier about the sort of limited scope of your theory, as it is right now anyways, I wonder if the sort of comparison is sort of not apt, like in the following way. Interest theories have sort of been like fruitfully extended to account for rights as a sort of unified phenomenon, and as the appeal to interest is sort of explanatory in a different way. So, for instance, lots of people have worked on animal rights based on interest theories, and rights of different, varieties of incapacitated persons, children, infants, stuff like that. And so that's one thing. And the other thing is that the interest theory seems to have a much easier, maybe sort of true to real life account of how we actually reason in these sort of situations. I think it sort of gets the epistemology right, in the sense that on the interest theory, we need to know a lot less in order to determine in a given, moral situation whether we should act or whether the person has a right to be saved from drowning, for instance. Because it seems that there's going to be a lot of cases, even for people who are not incapacitated, where the question, engaging in this sort of counterfactual reasoning, is going to be very difficult. It might not mean not always, but I just think that there's two things. One is that it might be very hard for us to be in a position to have a justified belief that the person is actually that either has the capacity to or will reciprocate. But also there's lots of cases where it seems almost impossible to know, like the rights of people far in the future or in other, in other countries, stuff like that. So those kinds of considerations, I think that, like, I agree that your theory explains the sort of forfeiture conditions better than the interest theory. But these other two things, the sort of scope, providing a unified theory, and, and the epistemology, seem to be better explained by the interest.
Good. Yeah. Good. So, so I think you're right that describing this as a rival of the interest theory is in some ways misleading, because in some ways interest theory is just doing different things to what this theory is trying to do. And there are some people who believe that we shouldn't treat interest theory as a normative theory of rights at all. It's purely an analytical theory. It's just giving an account of what rights are, just a formal analysis of the meaning of rights. And that's not what this theory is trying to do at all. So it's only a competitor for those, like I think is true of Raz, who want to view this really as a substantive normative theory. And it's not a competitor in the sense that it's, it doesn't claim to kind of replicate the scope of explanation that interest theory is trying to do. But if it's true, as I claim, that this theory can give us a good account of some of these really, really core rights, like interpersonal rights against harm and rights to assistance, and that the interest theory, understood now really as a normative theory, really can't, then I think to that extent, I think it really is a competitor. And I think then you have to go, you have to go and ask yourself whether we can actually regard interest theory as doing a good job at explaining those other broader domains if it can't, as I claim, really account for these things at the core. On the epistemology, you're right, that is an advantage, or would be an advantage, in the sense that it's much epistemologically thinner. But the question I guess you'd have to ask is whether that epistemological transparency has been purchased at the cost of an inability to give an account, as I claim, of some of these really core features like forfeiture. But yeah, you're right to say that there's a very complex relationship between them, and it's too simplistic just to describe them as competitor theories.
Stephen.
Hello. My question that I wrote about this week. I thought that even though it is rational and moral that if a person is, say, attacked in a park by someone else, and the attacker has a gun that you used on, I think, page 32, and the only way to save yourself is to use someone as a human shield or endanger someone's life. I felt that if that's used as a thought experiment, or it's used in cases where, in calm conditions, like the jurists deciding and academics deciding, it seems that it does fulfill the moral and juridical requirements. But my case was, as a philosopher, I don't believe that there is free will. I think that we're bidirectionally determined. I don't think there is free will, and because of that, I think the entire legal system suffers, because I think it's based on a metaphysical foundation that I personally think is untrue by studying philosophy and considering it. But then I felt, well, how will I definitely able to prove that, where for 2,000 years, people believing in free will and libertarianism have, and versus determinism are still arguing that point. And then I thought that I discussed it like from a neurophysiological perspective, where I considered, like, in cases of great duress, even the British common law looks at compulsion in those cases, even when people have been forced to eat human flesh or kill other people in these horrible conditions we all hope will never be in. And I think that, what it is the law is definitely recognizing in some cases that there is not free will.
Oh, sure, yeah.
I don't think there's free will really in any condition. I think it's more on a dimension.
Yeah.
And because of the compulsion that I mentioned, like from a legal perspective, I think that if you look at it from a neurophysiological and neuropharmacological viewpoint, when you consider how, under a case of duress, you have the fight or flight response is activated. And there's noradrenaline and there's cortisol, which is released.
So yes, I think I see where you're going.
And it precludes reasoning, and you will do anything to save yourself. Like it's just an animal response.
Sure.
It's directed, and that, I mean, I'm sure any person, myself included, if I used someone as a human shield or did something, I'd feel guilty for the rest of my life.
Sure. Yeah.
But I wouldn't
Stephen,
really.
Just a question, if possible.
Oh,
well, so
okay.
I think
I really wouldn't feel that I should be charged.
Yeah, good. So I think I get the.
My question is, don't you think that consideration that someone really should sacrifice their life for a stranger in that condition, doesn't it set the bar too high, considering how I think any average person or anybody in that situation would react if your existence is on the line?
Good. Okay. So listen, I think there are two things there. So the kind of deep question about whether there is such a thing as free will, it's obviously a huge question. If there's no such thing as free will, we can all pack up and go home because, ultimately you have to believe, in some kind of compatibleness. So it's a real question, but just really, really big one. So on the stuff about kind of duress and the overwhelming, experience of the situation and the kind of neurological components, all of that, absolutely that's right. But I think we need to draw a distinction here between justifying conditions and excusing conditions. So you're right to say that in a situation like that, if I used Francois to protect myself, probably no court in the world would convict me of culpable homicide. And the reasons are for exactly the ones that you gave. And in a situation like that, under pressure, under fear of your own, there's a famous quote, I think by Blackstone, who said, detached reason cannot be expected in the face of upraised knife, right? So we make allowances for that. But the crucial thing is we allow at the level of excuse, not at the level of justification, right? So we say the situation was so awful that nobody could reasonably have been expected to behave otherwise. But nonetheless, you didn't have the right to behave as you did. And that has really significant consequences, right? So you said you would feel awful about it afterwards, but you'd need to do more than that, right? You would need to presumably do something to make good to the victim or to their estate the wrongful harm that you had done on the person in that situation, right? You would need to go and apologize, to compensate, to do something to make it right. None of those residual obligations you would have if you killed a culpable aggressor in a situation of self-defense. So that tells you that even though we don't hold fully responsible for the purposes of punishment, we don't either justify in the way that we do in a standard case of self-defense. And that's really significant. It's significant for ethics and it's significant for law.
Thank you. I understand that now. There were a lot of interesting points in your paper, but I could only write one comment, so
sure.
I thought that was the most salient one.
Thank you.
Oh, go ahead.
Microphone, if possible.
I think you already touched on this, but to elaborate on Sam's question of capacity, what if we were to change the example instead of a paraplegic with a child? Let's say little Bob is walking down the street and he's on his Game Boy, unaware that a truck is about to hit him, and you pull him out of the truck's way and you save his life. And then all he does is just shrugs it off and then keeps on walking. So he doesn't have this capacity to understand the reciprocity, the respect and consideration you just gave him. I guess, what was I trying to say? Of course, is this question that you already touched on, that perhaps in the future he'll understand what you just did, but is the relationship between the person who just assisted him, who just helped him, does it become unilateral at that point?
Yeah. So look, these problems are really tough, right? they're notorious problems for the will theory of rights, right? So, for will theory, where you have to have certain kinds of capacities to exercise powers, you can't have rights of your children, you can't have rights if you're incapacitated, if you're comatose, certainly not if you're an animal, right? So it's a really, really deep problem. So what do I say? I say, look, at the very least, my theory is in a better position than the will theory, right? That might have put the bar too high, but it's better than the will theory, at least in the sense that I think I can give a much better account in terms of negative rights against harm, right? Because my account is much more minimal. I don't say that you have to have really advanced capacities, like the capacities to exercise a power. You don't even need to necessarily have the capacity to act, right? So that, I think that a comatose person is respecting my right to life by not killing me. And I think that that's, that is normatively significant in itself. So I think as far as negative rights against harm goes, I'm in a better position than the will theory. I think in terms of rights to assistance, I'm in an okay position, probably in a better position than the will theory, in the sense that I think if we do take this counterfactual interpretation of it, which I agree with Francois, it raises different kinds of problems, but I think it at least helps with situations like this. But is it going to go all the way? Probably not, right? What about a 3-day-old infant? If you apply the counterfactual test to him, would the 3-day-old infant provide some kind of very complex assistance to me if our situation reversed? Clearly he wouldn't. So the problem, it's very, very hard to solve completely. And I don't know what to say about cases like that. Sometimes I think that the best that we can say in cases like that is that we extend rights just as a kind of form of grace, right? We say they don't actually possess the features that we believe give the best account of how these rights get going, but we extend them anyway. That's not a great answer philosophically, right? But I don't know, I kind of feel that we may be doing something similar to that, something like that when in cases like this. But I don't know, there may well be a richer philosophical argument to it, but I don't know.
Yeah, I agree with you. I was thinking that perhaps there's an emotional underpinning, like we just feel.
And you don't want to have to say that, right? It's pretty bad when you have to, but I.
Yeah.
Justin, you have a follow-up?
Sure.
Or.
Thank you. One of the things I like most about the theory is the idea that we can sort of take our rights into our own hands.
Mm-hmm,
and just following up on what you just said, do you believe that each person can sort of be responsible for determining the content of their own rights? I mean, not only deciding the force of which particular rights we have, but which ones they want to enforce against others.
Right, yeah. Yes, I do, right. So it's a really good point. So what I think is really attractive about this theory, or really repellent, depending on your perspective, I think, is that it attributes to humans the responsibility for determining what rights they possess in a way that I find very attractive, but I suspect that many people will find very, very disturbing, right? So it doesn't say, like the Universal Declaration says, that we all get all of these rights just because we're humans, right? We get them for free. They just come. It says, no, you don't actually get rights for free. What you get is the capacity to bear rights. Right? Everybody gets the capacity to bear rights, but the particular rights that you bear is up to you, right? Now, I think it's very attractive in a number of ways. One, and I touched upon a number of those in the paper, but one way in which I didn't touch upon it is when you think about morality, it presents to us in a very kind of distinctive and peculiar way, right? So it presents to us in a way that is, in a sense, objective, right? It's clear that we can't just make up the rules of morality that we want to abide by, right? It's clearly, the kind of the subjectivists and the relativists who say they're just clearly wrong. It presents to us as something that is objective in a sense. But equally, morality, systems of morality are obviously, in a very basic way, self-generated, right? They're not baked into the physical structure of the universe. They're not there in atoms and electrons. They're obviously things that we generate as human beings. So we get this picture of morality as, on the one hand, being objective, but on the other hand, as being clearly self-generated. Now, what I think is really attractive about this account is that that's exactly the picture that the reciprocity rights approach is giving you, right? It's saying it's objective, right, in the sense that the things that I'm appealing to are objective facts, right? It's an objective matter of fact whether I am giving you certain kinds of consideration and respect, abiding by obligations to you, harming you, and so forth. Those are observable, objective matters of fact. So too, in a slightly different way, are the counterfactual considerations that we were talking about. Slightly more problematic way, but again, an objective matter. But at the same time, they're clearly self-generated, right? They're generated out of the moral relationships that we have with each other. And I think that's a really attractive feature of the account.
Maybe just to come back to the point I was making earlier, that last comment puts it in, I think, sharp relief, right? So if we go back to the bystander argument, the bystander example, where I grabbed this person who was intending to kill me 10 minutes later, but at that very point was complying with my right, and therefore you're saying, well, he has not forfeited his right. It seems to me that the fact that we're attributing rights to this person is actually something it's very fortunate for him, right? It's a matter of law, right? So insofar as we go down with the counterfactual basis, then I can see that there's more of a room for determination. But insofar as the simple matter of compliance, which is I happen not to be violating your right, is the determinant, then we're stepping away from that, right?
Right. So yeah. So the thought there is, well, to what extent is this really a matter of responsibility when in fact it can turn on matters of luck? That's right. That's right.
Because that's very important because it's a sharp distinction in your account. What you want to say, actually, the actual compliance is much more important. Right? This is what you use as argument against Cecile, right? To say actually, this is not the same kind of race that we're talking about here.
Yeah.
And it seems to me that your account might lead you towards an argument, at least on the counterfactual fact, which is to say actually it's not as important in this case, right? If really this person was intending to kill you 10 minutes later.
Right. So my gut intuition is that, well, what I have to say is that the actual compliance is always or almost always trumping the counterfactual, right? Now, in one sense, that's consistent with the overall story that I want to tell, because the overall story is one that's differentiating the stringency of rights against harm, which are saying, these cases of actual compliance, with rights to assistance. So in that sense, it's kind of, it's commensurate with the overall story that I'm telling. But clearly, what I need to say a lot more about is what happens. Well, first of all, why it should have that moral implication. Right? So intuitively, it seems that it does, and the different roles that they play in rights against harm and rights to assistance seems to underlie that. But we need an explanation of why that's happening, and we need an account of how they interact in situations like the one that you give, where the actual compliance and the counterfactual diverge, right? So those are.
Because you put it in terms of desert, you say, do we deserve the rights that we have? In this case, I would say, well, I'm not sure if you deserve the rights that you have. You're actually a callous murderer who was actually going to kill me.
Right. And so again, I think that there may be issues of language which has been less than clear, or at least is implying things that I don't want. So in general, I'm not a friend of desert, and if I use the word desert in the paper, it probably needs to be excised, because
you used it orally. That's why.
Right. Okay. So in general, I think desert is the wrong concept to be using about. So let me try and articulate it a little bit more carefully. So I think probably what we ought to say is that we are due or owed certain forms of consideration, because and to the extent that we give consideration and respect to others. Now, again, I have to be very careful about the wording that I use, because the giving doesn't imply active agency. It doesn't imply intention. There's no mens rea condition. It simply means that it means being in compliance with the duties that you are actually over. Right? That's all it means. That's what it has to mean for me if I'm going to get around these things, right? And so now the question is, well, is that a plausible principle when specified like that, right? Is it, the principle specified, you are owed consideration to the extent that you are complying with the obligations stemming from the rights of others. I think it does. I think that is intuitively a meaningful principle, but yeah, I think that's the.
Because I tend to get it out of these bystander problems using that doing and allowing distinction, right? Which is less of a reciprocal principle.
Right. So one of the interesting things that would be very interesting to think about, which I haven't done yet, is how this account interacts with doing and allowing. Okay. And I have not at all started on that project, but it would be a really great project.
Okay. Any further questions? Yes, Michael. That will be our last question.
All right. It's actually just a quick follow-up. I'm actually curious that, given the introduction and background of just war theory and whatnot, did this project arise somewhat out of, I guess, even rights imputed to states towards, we have a right, not to use force in international context unless for purposes of self-defense? Because as we're discussing these questions of, compliance and intention, I'm just wondering, did this come about, when you were thinking about, states and, preventative war and all those concepts? I'm just curious which came first, is it that and then this, or how you thought about this and then you're going back to the international kind of rights issue with states? I'm just curious.
Exactly. Well, so we haven't thought about states in terms of just war theory for at least a decade. So that's the kind of this. But Francois is going to come along and tell us all why we're wrong to do that. But for the last decade, as you may or may not know if you don't work in this area, but there's been a big transformation in just war theory towards a view sometimes called the revisionist view. I've written a lot in this area, and the revisionist view basically says that we have to think about questions of justice and war very much from the perspective of individual rights, rather than from the perspective of rights of states or other collective entities. So it hasn't been specifically in terms of an interest with rights of states, but yes, it has been very much driven by an interest in the whole series of questions around ethics in war and the ethics of harming and killing more generally. So, I mean, if you think about the kind of two big dynamic strands of international political theory over the last decade or so, one of them has obviously been the global distributive justice component. And so those guys, they think about how to kind of get rights to people, right? And particularly they're trying to overcome all of those intuitive ideas that I started with, right? The idea that there's somehow greater stringency that attached to rights against harm than to rights to assistance. They try to overcome, the kind of the idea that rights can be, that are importantly localized to state or national communities. All of those kinds of intuitions which I began with. That's what they spend all their time thinking about. If you're in the just war theory business, like I am, we spend all our time thinking about completely different questions. We spend our time thinking about how people lose rights, right? Because the basic question in the ethics of war is, how do people who start with rights, specifically the right to life, how is it that they become liable to be killed? And who is liable to be killed and who is not liable? So we're immediately thinking about a very different set of questions. We're thinking about questions of how rights change over time, how they can be lost, under what conditions are they not lost. And so, and when we do that, we implicitly have to invoke some kind of a theory of the kind that I'm talking about how rights, what rights are, where they come from, how they function. But very few people within the just war community are very explicit about the kind of theory of rights that they're utilizing. What's interesting about Cecile Fabre's work, which so this paper is actually coming out in a symposium on her book, is that she is very explicit about the theoretical underpinnings. So she's explicit about wanting to use a Razian interest theory. Now, it should be absolutely clear that theory is not going to work for this for this kind of account. And it became increasingly clear to me that the way that the kind of theory of rights that I'd been intuitively utilizing is very different from pretty much everyone else out there. So Jeff McMahon, who many of you know is really one of the leading thinkers in this area, he again says very little about the basic theory of rights that he's operating with. But to the extent that he does, he often talks about a kind of justice-based theory of rights. So what he'll often say is things like this. He'll say, look, in situations where one person has to be killed, classic self-defense situation, then it's more just, well, there's a harm that's going to be imposed on someone, right? He says that, it's more just that the harm be imposed on the person who was responsible for the fact that the harm needed to be imposed. So there's a kind of principle of distributive justice at work. But it's never really fully fleshed out. And when you think about it, it doesn't really make sense in a whole series of cases. So think again about the bystander case, right? So I'm an innocent person being attacked by the aggressor. Francois is an innocent person just standing there. Neither of us are responsible for the fact that we're being attacked. From a distributive justice perspective, it seems completely arbitrary who bears the harm. So why can't I push it onto Francois? Or if I can't do that, why can't I flip a coin? And if it goes heads, too bad for Francois, right? It doesn't seem to be a matter of distributive justice, at least in that very simple way. So I think we need another kind of theory. And I think reciprocity theory works really, really well for the forfeiture cases. And so the challenge is how far and how wide you can push it, how much of an explanatory role it can play.
On this note, I'd ask you to join me in thanking Professor Dr. Rodin for very, very engaging paper, which will lead us into interesting discussions. Our next speaker in this series will be talking to us about global justice, so it's a fantastic segue that we end with. Thank you very much.
Thank you.